Employment discrimination in general. Employment discrimination refers to the illegal practice of making employment discrimination based on employees' age, race, gender, religion, national origin, or physical disability. The primary federal anti-discrimination statute is Title VII of the Civil Rights Act of 1964. The United States Equal Employment Opportunity Commission (EEOC) was established by Title VII and it's responsible for interpreting and enforcing the provisions of the Act. As more fully discussed in this chapter, Title VII prohibits discrimination in hiring, promotion, discharge, pay, fringe benefits, and other as part of employment or the basis of race, color, religion, sex, or national origin. Most private employers, state and local governments, educational institutions, employment agencies, and labor organizations are subject to this Title VII, which cover both current employees and job applicants. As further discussing in this harmonic, there are a number of other federal and state statutes which also prohibit employment discrimination. The Americans with Disability Act of 1919 prohibits employment discrimination against individuals with disabilities. The Age Discrimination in Employment Act of 1967 prohibits discrimination against individuals because of their age. Some of the state laws are patterned after the federal statutes and provide similar protections to workers employed by those employers not covered under the federal statutes. Some state laws also extend protections to additional groups not covered by the federal laws. Thus, the readers is advised to check the laws of our or his or our own jurisdiction when researching employment discrimination matters. Different types of employers are subject to different laws as more fully described below. The 5th and 14th Amendments to the United States Constitution also limit the power of the federal and state government to discriminate in employers. For example, the 5th Amendment forbids the federal government from deriving any individual of life, liberty, or property without due process of law, and further requires that there be equal protection under the law. The 14th Amendment makes the prohibition contained in the 5th Amendment applicable to the state. Therefore, state and federal government employers are constitutionally prohibited from treating employees differently based upon race or gender. Private sectors. Private employers as well as state and local government and public or private educational institutions, employment agencies, labor endowments, and protective programs are subject to the anti-discrimination laws listed below. The private sector, however, is not directly prohibited by the constitutional provisions discussing above. Title VII of the Civil Rights Act of 1964. Title VII of the Civil Rights Act of 1964 as amended, prohibits discrimination in hiring, promotion, discharge, pay, fringe benefit, and others aspects of employment on the basis of race, color, religion, and others aspects of employment on the basis of race, color, religion, sex, or national origin. Most private employers, state and local government, educational institutions, employment agencies, and labor organizations are subject to Title VII, which cover both current employees and job applicants. Title VII prohibits not only intentional discrimination but also practices that have the effect of discriminating against individuals on this basis. The following discriminatory actions are prohibited under Title VII. Thank you. God bless the United States of America. Thank you. God bless America.